an email I recently got from the Court of Appeal in Ireland. And quite a while ago, I was sort of dragged into this the civil court for preaching, even though preaching is not in any way unlawful in Ireland. And I was told time and time again, look, you're not doing anything wrong, but people are complaining. As though people complaining in and of itself was reason for me to cease doing what is otherwise a perfectly constitutionally accepted activity and in no way antisocial. First of all, antisocial means unlawful. So if something has been declared as lawful, it cannot therefore be also antisocial. Now somebody might say, well, in your delivery, it was antisocial. No, it would have to be menacing behaviour in order for it to be in any way unlawful. And then the guards should have arrested me. They shouldn't have tried to implement an adult behaviour warning and conspire with members of the public to drag me before the court when otherwise they couldn't arrest me. So as we see, the section under the Criminal Justice Act 2006 is unlawful, that says guards can prosecute in court, where the High Court have recently ruled they cannot actually prosecute in court, nor can they even represent the evidence of another member of An Garda Síochána, both of which the legislations or the sections of the Criminal Justice Act 2006 offend directly, because they incite members of An Garda Síochána to prosecute in court and also to represent the evidence of another member of An Garda Síochána, evidence they had nothing to do with the accumulation of. So here we see that the term antisocial behaviour has been thrown around like confetti without any lawful grounding. And antisocial behaviour is not actually something that exists previously in the Constitution of Ireland. We have specific laws, and there are laws that govern speech, and they are anti-obscenity and the anti-inciting of violence. So unless you're doing either, your speech is not unlawful. Obscenity is lewdness, salaciousness, or things of an overt sexual nature. Like if you were out there describing sexual acts or something like, debauched or perverse or depraved sexual acts, or trying to incite others to take, part in them in public or something, that would be considered obscenity. Now, in this instance, it would be against the law to speak things of an obscene nature. But that again, obscenity is something of salacious, lewd, or overtly pornographic nature. Then the other thing we have is the inciting of violence. The inciting of violence is very specific, though. It actually directly deals with trying to incite other people to physically assault or oppress members of society, in the way that I'm being oppressed at the moment. Like, I'm not being given rent allowance, I'm not being given HAP, even though I've satisfied all of the necessary documentation and I've been told that I'm eligible and all of that stuff. My eligibility is confirmed, and they were engaging with the agent here, and they just pulled out at the very last minute and said, look, we're not giving you any money. So they have me living below the poverty line now in society, and this is clearly oppression. It's the oppression of a Christian. And but back to the point I'm making. So if you were to incite that against somebody in public, that would be considered inciting violence, because you're actually going out of your way to try and harm the life of the person, or even the economy of the person, their financial stability. That would be harm. That would be purposeful harm against that person, and that would be considered inciting violence when you're encouraging others to partake of that. At no stage have I done any such thing. Terms like homophobic and racist were thrown around in the newspapers, but none of them were confirmed in court as having been evidenced or done. So the main point is, throughout all of this court case, and from the civil court, district court, to the circuit court, to the High Court, to the Court of Appeal now it's at, no solid, irrefutable, substantiated evidence has ever been given to a court against me to say that I in any way broke any law or behaved in an antisocial manner, because the two terms are interchangeable. antisocial behaviour cannot be anything other than unlawful behaviour. So you have to have broken a law in order to have behaved in an antisocial manner. The two are not mutually exclusive. They're not. You can't just say you behaved in an antisocial manner, therefore I'm removing your rights as an Irish citizen. You have to show how that person has actually broken the law, and that has never been done in my case. So the High Court rightly ruled that this man's conviction should be quashed. But for some reason the state pursued me to the Court of Appeal. They didn't put in an extension to appeal. They didn't apply for an extension to appeal, even though they were a month and 4 days late after the final hearing date. They applied a month and 4 days late. The Court of Appeal instantly accepted their appeal, even though they appealed late. So the basic procedural and administrative protocols of the court were not satisfied, so jurisdiction wasn't established. Not really. They didn't really have a jurisdiction to actually have the appeal hearing at Court of Appeal level. They had 3 judges there in the Court of Appeal. One of the barristers representing the state made false accusations against me, saying that I had agreed with the judge in the first instance that I had behaved in an antisocial manner, which was not at all the case. At no stage in court have I ever agreed with a judge that I behaved in an antisocial manner. In fact, in my first interaction in the civil court, after having been brought into the court through the adult behaviour warning system legislated for under section I think it's 113, 114, 115 and 117 of the Criminal Justice Act 2006, those sections there aforementioned, they basically said, you, sir, are behaving in an antisocial manner, but had no solid, irrefutable evidence to back that up. And so I actually asked the judge in court, I actually said, Judge, do I have a reasonable excuse now not to comply with this civil order? Being that you're telling me I'm free to go, I'm an Irishman, and I have had my rights in no way reduced. Because the civil order was you cannot speak or record. Sorry, yeah, you cannot speak or record in public. Oh no, sorry, it was the exact wording was you cannot speak and record in public. So they went about doing that. I appealed to the circuit court. So how does an appeal to the circuit court show that I agreed with the judge that I'd behaved in an antisocial manner? How does my refusal to comply with the civil order banning me from speaking and recording show that I agreed with the judge that I had behaved in an antisocial manner? For a barrister at law who wasn't there in that court to say that I agreed with the judge on the first day in court that I had behaved in an antisocial manner is outrageous. That he would lie about me at a court at that high level, blatantly and barefaced in that manner, is absolutely criminal. So, firstly, guards have no jurisdiction in civil matters, so they should have no power of cease and desist outside of court. They cannot tell a man, you must stop doing this based on merely the fact that Mary would rather you didn't say that. They can't function on that level. Do you understand what I'm saying? So they're not entitled to just play judge, jury, executioner on the side of the street and say, well, Mary said, you said, so you must stop doing. No, you must presume I'm innocent. That's what you must do as the guard. You must presume that I'm innocent. It's called innocent until proven guilty, or presumption of innocence, as you might see it termed in law in various different jurisdictions. But it's the same mechanism. You must assume that somebody's innocent. Otherwise, anybody could say anything about anybody and a guard would be going around like a headless chicken, picking and choosing who he's going to believe. There has to be some kind of solid irrefutable evidence to back up the claim. So the fact that a barrister at law representing the state of Ireland is pursuing me in a court of appeal, even though the High Court, who are better equipped, who had barristers at law than any state barrister, to make a ruling on whether I'd behaved in an antisocial manner or not, has quashed my convictions. The High Court have quashed my convictions. Yet a barrister at law in the state who's lying about me, fundamentally, and doesn't understand why why there needs to be a Court of Appeal hearing is totally losing the plot, is totally a corruption of his position, and is blatantly satanic, because it's an abandonment of all that is reasonable and logical in society. How can a barrister at law, who's supposed to have a high standard of education in matters of the law, not understand that the only reason he would be appealing a High Court decision, which initially quashed the convictions, was because I sought the quashing of the convictions, which basically and fundamentally states that I don't agree with them? So how could he then say Stephen actually agreed that he behaved in an antisocial manner? It was like a scallywag ran into the court and just thought to say the most unthinkable thing you could possibly say at that moment and then run out of the court. Except it was a barrister at law. So, I mean, the fact that these things are actually playing out in our courts is absolutely demonic and satanic and a sign of the times. They want to now have a remote hearing. They've told me 6 days prior to the remote hearing that it's going to be had. That's the amount of notice they've given me. Today's the 19th. Now they're saying on the 25th we'll have a remote hearing and we'll give you our judgment. They haven't even established jurisdiction to give a judgment. They didn't appeal in time. They were a month and 4 days late. And they didn't apply for an extension to appeal, which means that there's no jurisdiction of the Court of Appeal. They haven't established jurisdiction. They haven't submitted to procedural administrative protocol. They haven't established jurisdiction. The High Court established jurisdiction. They made their ruling. They quashed all of the convictions. They said that they've all behaved in a way that is an ultra vires of any section. In other words, they behaved outside of the law. And now a barrister at law thinks he knows better than the High Court, and he can't even tell the truth on the basics of why we're there, claiming I agreed that I'd behaved in an antisocial manner. And all you have to do is seek the DAR to hear that he said that. The digital audio recording of the hearing in the Court of Appeal. You can seek that, anybody can. And they're blatantly barefaced lying about me in the court. Barristers at law, on the bar, under oath, lying about the basics of the case. The fundamental premise of the case. If I agreed that I behaved in an antisocial manner, why would we be in the Court of Appeal? Doesn't make any sense. He hasn't shown that he has a grasp of the basics. Is he to be considered over the High Court of Ireland for being better positioned to know better than the court, the High Court? He hasn't even understood or submitted to the basics of the case. That I don't think I behaved in an antisocial manner. He's claiming before the 3 well-paid judges of the Court of Appeal that I agreed that I'd behaved in an antisocial manner. I didn't even comply with the civil order because I didn't have to, as the High Court later showed. So if the High Court showed that I didn't actually have to comply with those orders, anything that came as a result of my failure to do so is naturally quashed and cannot be overturned. If you say that I shouldn't have been convicted, that means that I comply with the initial civil order. So even failing to comply with that civil order wasn't breaking the law, because the civil order was given outside of the law. It was an ultra vires. The first gathering in the civil court has been shown to be on an unlawful basis because it required a member of An Garda Síochána to prosecute. He's not allowed. That's the point. Therefore, the legislations that tell him he can must be removed with immediate effect. And because of their reluctance to admit their defeat, they're still pursuing me in the Court of Appeal against all of the laws. That will show you how defiant and disobedient those people are. They haven't even applied for an appeal in time. Like, we're not just talking about a day over or something. And even if you're a day over, by the way, you have to apply for an extension to appeal. Even if you're 1 day over or one day late with your appeal, you have to apply for an extension to put that appeal through. They didn't do any of that. Even a month and 4 days late, they didn't put in an extension to appeal. Do you know why? Because they were probably too late with that as well. But the Court of Appeal are still accepting the appeal, and then are allowing members of the bar to say that I agreed that I behaved in an antisocial manner, even though none of us would be sitting there having a discussion if I had. Basically, nonsense. Look, guards cannot give you a cease and desist order on the basis of a complaint of a member of the public. They can't. They have to presume you are innocent. A guard can't say, Mr. Tallon, you're well within your rights to do what you're doing here in preaching, that's no problem, but because Mary complained about your subject matter, you must stop. Why? Am I not allowed to talk about anti-abortion? Am I not allowed to say that I don't agree with Islam? You are. Am I not allowed to say that Christianity believes that same-sex marriage is a sin? You are. Well, what about, how have I broken the law then? Mary doesn't have to agree with these 3 subject matters. But because Mary doesn't agree with them doesn't mean it's against the law or antisocial. She doesn't have to agree with them. But I don't have to stop talking about them either. I ask you, if it was reasonable to say that somebody who believes pro-abortion legislature is evil, if it's unlawful for them to actually voice that and campaign against it, how did they hold a referendum in the first place? It's obviously not against the law if people could campaign against it. And just because people have voted it in doesn't mean you can't campaign against it again. In other words, just because pro-abortion legislation now exists doesn't mean we can't campaign to have it removed. We can. It's well within our rights so to do. So for somebody to say, for a guard to say, because Mary doesn't like what you're talking about now in terms of you're against abortion, we're going to say that you're behaving in an antisocial manner and you must stop doing that now. Doesn't work that way. I'm allowed to come out against pro-abortion legislation. I'm allowed to answer questions surrounding gender and same-sex marriage as it pertains to Christianity. Of course I am. I'm allowed to discuss other world faiths and explain as to why I believe they're not the true faith. Of course I am. Is saying that you don't agree with Islam racist? Of course it's not. So when I want you to understand that the whole basis of them writing racist and homophobic in the newspaper, racist because I didn't agree with Islam. Well, guys, Islam isn't a race. It's a worldview. There are people from all sorts of ethnicities involved in Islam. So to say that I'm racist because I don't agree with Islam is just ignorant. To claim that I'm homophobic, by the way, phobia is a fear. Homo means same or man, depending on whether you're talking about Latin or Greek. So I think it's probably same is probably the meaning we can deduce from that. being as it applies to both men and women, homosexual, so meaning of the same sex. So with respect to matters around sexuality, yes, as Christians we are entitled to discuss those issues in public, absolutely, and it's not antisocial to discuss them. That would be ridiculous to say that it's antisocial to discuss matters of a sexual nature. Now, of course there's a line. We don't need to be getting into any great detail, but I think children know that the anus is for defecation. We've all, from very young, we've been doing poos, and we know that things are only supposed to come out of the anus. So this is basic biology. You'd be taught this in young babies in school. We're taught biology and physiology and anatomy. So for anybody to, claim that it's against the law to discuss basic biology is obviously totally lost the plot. So if of course you have to choose your audience as well. Like if it's 4 or 5 teenagers coming up to me saying, "Hey, I'm a lesbian," or "My sister's a lesbian. What do you think about that?" Well, obviously, sometimes people are just going to come up to you as a preacher for a laugh. They just want to sort of bounce off you and play the fool before their friends. When I say that, I mean, when it play the fool, it just means like get a laugh out of them. Look at me talking to the preacher about things of a sexual nature. Ha ha ha! How funny is this? Record me. That kind of stuff. Look, I've done things like that as a teenager myself, where you're just messing around. You're just trying to get a reaction or get a laugh or whatever from the group people you're with. So that's just one thing. But to claim that answering the question as it pertains to Christianity is in any way unlawful because that person's declaring they're homosexual is absolutely ridiculous. Christianity says in many places, both in the Old and New Testament, that homosexuality is a sin. Unnatural sexual relations it's referred to as. So if unnatural sexual relations are a sin, then if somebody asks me about them on the street, I'm well within my rights to answer that. And anybody who tries to remove my rights merely on the basis of me discussing with young adults that about why Christianity or the belief of Christianity deems homosexuality as unnatural relations, or the Bible does rather, to claim that that's unlawful is totally outside of their box. Because the Bible is not a banned book and it's in no way obscene. So actually the Bible establishes the manner in which we should discuss issues of a sexual nature. And in Leviticus 18:22 it says, "A man shall not lie with a man as with a woman. It is an abomination." An abomination means it's something unnatural or perverse or something that God didn't intend. And it means it's an abomination before God because he didn't create man and man to lay together as woman and man. Do you understand? We're not, anatomically that doesn't work. So it's not in no way perverse or obscene to discuss that. Obscenity is specific to salaciousness or lewdness or things of an overt pornographic nature. Like if you're coming up to somebody and saying, propositioning them sexually or something, that would be unacceptable. That would be considered obscene. Especially if it was audible for other people in the area, like the youth or something like that. So there are lines that ought not be crossed. But if the civil court believed I'd behaved in an antisocial manner, surely they would get into the detail as to why they believed that, if they were actually making the ruling on the basis of actual fact and not just making the ruling because they were coming under pressure to rule against me by the community. So if you've behaved in an antisocial manner, it makes sense that the judge would have no problem telling you how you had done so. But because the judge hasn't told me in any way how I have behaved in an antisocial manner, his ruling wasn't based on any law. Excuse me, and that's why the High Court have indicated that the judge behaved in a way that was outside of the law, which he did. Now, how does a state barrister believe that he knows better than the High Court when he can't even grasp why we're there and thinks it's okay to lie about me in open court in the Court of Appeal, saying that I had agreed with the judge in the first instance that I'd behaved in an antisocial manner? If you go back through Word on the Street Ministries YouTube channel, go all the way back, you'll see interactions between me and the guards. You'll see videos there about me discussing what has happened in court, and at no stage would you ever get the impression that I agreed with the judge that I had behaved in an antisocial manner. From the very start, I had been campaigning against what the judge ruled. Absolutely. And exposing why it was criminal what he was doing. And I've gotten into fairly detailed videos describing why adult behaviour warnings are highly unlawful documents. And during my interactions with the guards, even before I went into court, I was telling them that the adult behaviour warning system was an unlawful system that I wasn't going to engage with because it would be aiding and abetting them in committing crimes, which the High Court later ruled upon. So because a guard is not allowed to prosecute in court, adult behaviour warnings and the systems and the legislation surrounding them are against the laws of Ireland. And the High Court has recently ruled that members of An Garda Síochána are not allowed prosecute in court. Members of An Garda Síochána are not allowed to represent the evidence of other members of An Garda Síochána, and that's exactly what the adult behaviour warning system calls guards to do. It says that a guard of no less than superintendent, the rank of superintendent, so a superintendent or higher, can go in and prosecute you in court on the basis of the evidence accumulated by his underlings or the ranks underneath him, which is two laws broken, which have been recently ruled upon, acknowledged and reaffirmed in the High Court of Ireland. Guards cannot prosecute in court. Guards cannot represent the evidence of other members of An Garda Síochána in court. Therefore, the whole case collapses, because the premise upon which I was first brought into court was unlawful. The conduct of the superintendent was unlawful. So it falls down like a house of cards. But they're still pursuing it and have ratified a ruling at Court of Appeal level, despite the fact that the state have appealed a month and 4 days late. So it just goes to show you how corrupt the system is. That at High Court level, they're still trying to push this when it's against the law for a guard to prosecute, which the whole case rests upon. The whole thing rests upon the guard going into court and prosecuting, in terms of the antisocial aspect. So, I mean, it's absolutely ridiculous that they're pursuing this at Court of Appeal level. And the barrister at law is saying that I agreed that I behaved in an antisocial manner. I mean, this is just harebrained stuff. It's nothing short of what's the most unthinkable thing we can think to say now. We'll say that. It's totally lost the plot, guys. So now they're saying on the 25th of the 5th, they're going to make a ruling as to whether what the High Court of Ireland have ruled as unlawful in more than one case, both addressing my convictions directly and indirectly addressing whether a guard can prosecute in court or whether he can represent the evidence of another guard in court, the case falls apart. Even though it falls apart, they're still pursuing a judgment and appealing those rulings at Court of Appeal level and spending taxpayers' money to do so. So they're employing the highest levels of Court of Appeal. 3 judges are being well paid. Barrister at law from the state is getting well paid. And they're pursuing me unlawfully in the Court of Appeal without any timely application to appeal or even an application for an extension to appeal, even though they appealed a month and 4 days late. It's totally corrupt. It's totally against the laws of Ireland. And if they pursue it, they commit high treason. Blessings in Jesus' name.